corporations have the same rights as people, and in fact, the framers hated the idea of consolidated corporate power as much as they hated the idea of government power. But the court seizes upon this. By the way, they've been playing with it for a long time, right? They basically did this several years before in the Austin case. It's just that none of us really noticed. But it's a metaphor, and the metaphor makes people nuts, right? The metaphor is, corporations are people too, and everyone goes crazy. And what I want to really impress, if folks who are listening and watching do nothing but this, Citizens United isn't the problem. The problem is a long line of other cases that we don't talk about. It's not that corporations are people. It's that in case after case about incredibly boring things like standing in the Iqbal case and incredibly boring things like the right to arbitration in AT&T versus Concepcion, and incredibly boring things like the power to create a class for a class action suit in the Walmart case. In case after case after case, there's a Janus Financial case from last year. These are cases that are never on the radar because they're incredibly doctrinally boring. And in each of these cases for years and years and years, the court has constructed an edifice that lets corporations win and people lose. And they do it by not saying that corporations are people, but simply limiting standing, limiting the statute of limitations, limiting, right, this is the Lilly Ledbetter case, limiting your ability to go into court and redress wrongs. That's the sin of the Roberts Court. It's not Citizens United. Citizens United, and I'm not saying it's not a hugely consequential thing to put more money, more corporate money into elections. It is, but that is the icing on the cake, and the cake itself is a series of cases that have gone on for years undetected about limiting the ability for litigants to get a fair shake in the courts, closing the courthouse doors on ordinary litigants using incredibly technical rules. That's the thing we need to talk about. It's what we have to focus on, not Citizens United, but the fact that we cannot, if we don't have standing, if the statute of limitations is abbreviated, if all of these boring things that allow us to hold big corporations to account are limited and we don't notice, that's what we need to be looking at, and we're not looking at it. And so it just seems to me that that's what makes the ACA case interesting, is that Americans are going to have to look around and say, oh my God, are we going to do away with decades of unquestioned Commerce Clause jurisprudence in order to make sure that Americans can't get health insurance that they believe themselves to need? So I think that's what we want to watch for, is not the sort of metaphor that's really interesting about corporations or people. That was a one-off. It's the other things that we're not noticing that are happening under the radar that are making it impossible to get into court.
Well, it's tough, though, because it's hard to unite all of those different opinions under one legal approach or another approach, unless you approach it the way I was describing it, sort of as an ideological one, which requires people who are very, very well versed in all of the opinions to unite them all together the way you have. So it takes someone like you watching the court over a period of years to knit it all together and present it as a single unit to progressives and say, hey, wait a minute, here's what's going on. You may not have noticed because it was happening over a period of time in different ways to different kinds of plaintiffs. But if it takes the Citizens United case to wake people up, well, that's good too. But it's also a concern of mine, though, that if the court ends up upholding the law or kicks the can down the road, then people may have a big sigh of relief, and liberals will say, hey, we won. When in reality what you're saying is we're losing the long war, whether we win the health care ruling or not.
Not only are we losing the long war, but I've confined what I said in my little last 4-minute rant to the long war against sort of corporate hegemonic power. We're losing the long war on reproductive rights in the courts. We're losing the long war on environmental protection. We're losing the long war on affirmative action. We're losing, and you and I meant to talk about it. We're not going to get there tonight, but we'll do it next time. The long war on redistricting, and we're losing the long war on the Arizona immigration law. So it's not just one thing. It's the understanding that you can fight your entire life for reproductive freedom for women. You can fight your entire life for workers' rights and union rights. You can fight your entire life for clean water, and the court can reverse it with a stroke of the pen. That's what the Health Care Act really is about, that the court can reverse something with the stroke of a pen. And we don't understand that because all we see is the thousands of little victories that we see. We don't recognize that when the court upends Brown versus Board of Education to invalidate a Seattle school program that's supposed to integrate the schools, we have lost on affirmative action. We may lose again this year on affirmative action. The court doesn't have to strike down Roe. It was enough for the court to do what it did in the partial birth abortion case. That's where we're losing the long war, and I think that the inability to connect those dots, not even the sort of doctrinal in the weeds dots, but the big, big dots, and say each and every one of our fights ultimately ends at the doorstep of the court, and that if we don't make that connection, and it is the case, by the way, that Republicans made 30 years ago and have fought to the ground, if we don't start to make that connection, all of the legislative victories in the world won't matter. And that's the thing we need to really rally behind. And remember, and this is the sort of fear-mongering bit, Ruth Bader Ginsburg is the oldest member of the Supreme Court. She's a 2-time cancer survivor. If Obama is not reelected or a Democrat is not reelected in 2012, we are going to look at a court for the first time since before the New Deal that is going to be dramatically to the right of where this country is. There's no question about that. The court is absolutely should be one of the single most important voting issues this November. And yet I think that progressives have really, really hit the snooze button on the court. And we have this notion that either it doesn't matter or it's not our fight. And both those things are wrong.